Welcome to the Legal Aspects DVD training series. I'm Jeannie Gordon, the Legal Issues Training Coordinator for the Children's Division.
I'm Christy Collins, a Program Development Specialist with the Children's Division.
The topic for the day is the legal aspects of working with incarcerated parents. We've entitled it Breaking Through the Bars, Incarcerated Parents. The date today is February 10th, 2011. These materials are available on the intranet. Go to Practice and Professional Development. Go to the Legal Aspects DVD training series and follow the links. We're going to begin today with a question to Christy. Christy, what do we know about the children of incarcerated parents?
Well, in Missouri, there are over 60,000 children who have an incarcerated parent. Children have different reactions to parental separation due to incarceration. They may have feelings of guilt, anger, sadness, or even isolation. They may have difficulty coping with future stress, and parental incarceration may increase delinquency for the child and cause intergenerational patterns of criminal behavior.
So working with incarcerated parents is very important?
Definitely. And one thing it's important to remember as we go through this training today, when we talk about incarcerated parent, we're going to be referring to parents that are in prison, but also parents that are in jail, because it's important that we work with both of them from the beginning of the case.
Great. Let's take a look at the goals of the training. First of all, we would like for you to learn about the constitutional rights of the parties in child welfare proceedings involving incarcerated parents.
Participants are going to learn the need for and how to provide reasonable efforts to incarcerated parents.
Legally sound decision-making for concurrent planning is another goal of this training.
We're going to gain knowledge of the resources available to an incarcerated parent and understand the need for documentation and how to access an incarcerated parent's records.
Again, the underlying premise of all of this is that you are doing social work in an evidence-based legal system, and we're just going to put that within the context of the incarcerated parent. Our overall outline for the day is to begin with the laws that apply. Then Christy and I will walk through a case and apply those laws to a case involving incarcerated parents, and then Christy will conclude with a short discussion on the resources that are available. So let's take a look at the laws that apply.
Do incarcerated parents have the same rights as any other parent?
Yes, they do, as far as it goes with their children. They have what's called a protected liberty interest. That L word is very important to remember. The parents have that right in their relationship with their children, and the children have that right in their relationship with the parents. Incarcerated parents have the very same rights as any other parent. Let me repeat that. Incarcerated parents have the very same rights towards their children as any other parent does. If you look at one of the other bullet points, it talks about the federal and state laws that apply. Reunification applies in almost all cases with a few exceptions. But specifically note that there's nothing that says just because they're incarcerated, we don't have to work with the parents. Let me ask you a rhetorical question. Which is worse? A parent that's in prison, a parent that abuses his child, his or her child, or a parent that abandons or neglects their child? We know a couple of things. Either way, the parent has made a mistake, and in many cases they've lost temporary custody of their child, but it doesn't mean that their constitutional rights have gone away. So again, an incarcerated parent is just like any of these parents, and it doesn't necessarily mean they're any worse, and we need to work with them in the same manner in which we would work with any other child that's removed from care.
Well, that's a really good point, because some people might be incarcerated for nonviolent crimes like theft or passing bad checks, so it's really important that just because they're in prison doesn't necessarily mean they're bad or they can't have a relationship with their child.
And that's true. This next slide talks about due process, and due process means that a parent is entitled to notice and opportunity for hearing. In a juvenile court adjudication, that means that the juvenile officer is going to have to file a petition. There's got to be a summons. It has to be served on the parent, even if they're in prison. It tells the parent when the hearing is and what it is they've done wrong. If you remember, the state also has to make its case, and in a juvenile court jurisdictional hearing, the fact that the child is without proper care, custody, and control is an easy basis for jurisdiction when the parent is incarcerated. We will talk about how the same due process piece applies in both guardianships and your TPR and adoption cases.
So let's talk about reunification as a permanency plan.
Okay. There are lots of laws that apply to reunification. Under the Adoption and Safe Families Act, that's federal law. reunification is required in almost all cases. And under Missouri law, that's section 211-183, reasonable efforts are required in almost all cases. We're talking about most cases from the very beginning of the case, and they're usually 98% of the cases reunification is required. One of the things I'd like to bring up at this point is this is specifically a conversation on when a parent is incarcerated. We're going to assume that if you move to concurrent plans of guardianship or adoption, that the other parent isn't doing what they're supposed to either, and therefore you would be able to meet your burdens of proof on those cases. I just wanted to remind you of that. But for right now, we're looking at reunification, and we're talking about reunifying with both the incarcerated parent and the parent that is not. Again, these reasonable efforts are required, but there's nothing that says specifically that because they're incarcerated, we don't have to work with them. Let me ask you a question, Christy. Why work reunification with a parent who's going to be in prison for a long time, maybe even the child's whole childhood?
Well, just because the parent's incarcerated doesn't mean that they don't have the right to have a lasting relationship with their child. We need to remember that we talked earlier in the training that over 60,000 children have an incarcerated parent, and not all of those children are in custody. They find other ways to make it work by living with another parent or maybe living with relatives without court involvement.
There are additional laws that apply in terms of reunification. One of the most important is the diligent search requirement for the absent or unknown parent. The parent may be in prison or in jail, but you have to go look for them. And if they're in jail, they may not be in jail for just 1 or 2 days. If they're charged with something, they may not be able to bond out. They may be sentenced for 1 year or more in jail, or they may end up spending considerable amount of time in jail just while awaiting trial. So you need to be working with them in the jail from the very beginning, not in addition to those parents that are actually in prison. The second bullet point goes to that prohibition on reunification and placement. There are going to be a few of our parents that are incarcerated that have committed one of these Missouri felony sex crimes against this particular child in your case or another sibling, which is going to prevent reunification and placement. In those particular cases, there may be limitations on visitation and contact by the sentencing requirements in the criminal case or by the juvenile court order. We will always recommend, though, that you take a child-specific look at what all is going on in order to try to maintain the parent-child relationship. The third bullet point goes to the diligent efforts to identify, locate, and place with a relative, which are required. Parents in prison have relatives, and we can't really do doesn't the apple fall too far from the tree type thing. So what we really need to be doing is also looking at these relatives of the incarcerated parents. And by law, we're required to look for them just like we are the relatives of the other parent. Don't forget that every decision you make on the front end of the case will have an impact on your ability to achieve permanency on the back end of the case. Okay, Christy, let's walk through a case and talk about the parent in prison.
Well, first we're going to talk about finding, identifying, and notifying the incarcerated parent. Then we're going to talk about engaging that incarcerated parent in the process.
Close to my heart is the next piece on concurrent planning, and lastly, documentation and obtaining records. Okay, Christy, you go first.
Upon a child's entry into foster care, the worker should determine whether either parent is incarcerated. In doing this, it's important to search for offenders using the offender search application on DOC's website. Workers can also search the federal prison system, and we've provided both of those addresses for you. A complete diligent search must be made to locate both parents. We know that we have several different diligent search options available to us, and all of those are listed in our Child Welfare Manual. Some of the things that we could utilize to search for: ask the other parent where this parent is, ask the child if they know where their parent is. We can ask relatives, neighbors, or anybody else that's involved with the family. It might also be helpful to search prior history, including our FACES system, and we also have a form that we can use to request location services.
Christy, you talked about finding Dad. What about when we don't know who dad is?
Well, it's really important to find out who the dad is. And one thing that we've done in other cases when we don't know who the parent is we do paternity testing. And it's just as easy to do paternity testing with a parent that's incarcerated as it is with any other parent. We need to make sure that we have a court order. We follow the same protocol we would with any other parent. The only difference is on the form you need to make sure and list that the parent's incarcerated, and you need to give the address of the facility.
I'm going to move a little bit off topic here while we're talking about a parent in prison, and usually this comes up on the dads, but there are many cases where the dad, who is the incarcerated parent, may not be the biological parent of the child, but he may have been married to mom at the time that the child was born, or he may have been signed an acknowledgement of paternity. Either way, legal rights attach in those cases. Constitutional rights attach. The Missouri statute is 210-822. So it doesn't matter whether there's been paternity testing or not. It doesn't matter whether that man's name is on the birth certificate or not. Even the fact that he's incarcerated, he's still the father of the child, and we have to work with him. And the problem that comes up is it creates issues when we get to that concurrent planning piece, and we need to recognize that this man is a legal dad, whether or not he is a biological dad. On a practical level, many times when the man who's married to mom at the time of the child's birth will consent to a termination of parental rights or consent to guardianship and moving those cases forward. So that's the good side of that. But if we don't work with them, we may not have enough evidence to get to our concurrent plan.
So the way we notify an incarcerated parent about the child's entry into foster care is by sending them the Notice to Incarcerated Parent form. The form gives the parent information about their rights and responsibilities and also provides education to the parent about their ability to communicate with their child and to send gifts when appropriate. In addition to the notice form, we should also send the parent response form, which gives the parent information about their intentions and also provides them information regarding possible relatives that they want to look to for placement.
Does the relatives of an incarcerated parent stand on equal footing with the relatives of the other parent?
Definitely. We just need to look at all the factors, the proximity, the child's relationship with those relatives, and we need to take everything to the family support team meeting so they can make an educated decision.
What happens if that notification letter doesn't go out right away to the incarcerated parent?
Well, that can become very problematic, especially later on in the case when you have competing laws that come into place. The law requires us to locate and identify all the relatives within 30 days, including grandparents. So our failure to do that is a violation of the law.
That's a good point. I always like it when you bring up the law. What happens if the incarcerated parent doesn't respond to the worker's notification letter?
Well, we need to continue to engage the parent by sending periodic updates. We can send pictures of the child or drawings if appropriate. We want to make sure that we're notifying them of all family support team meetings so that they have the opportunity to participate. And we can also visit the prison or request a service worker to do that, to try to engage that parent. We can't just notify them once and if they don't respond, assume that that's the end of it. We need to continue those reasonable efforts throughout the life of the case until we reach permanency. In addition, we talked about the Notice to Incarcerated Parent, but we should also send them a copy of the Know Your Rights brochure and a handbook for parents of children in alternative care, which is a handbook that provides a lot of information to the parent about the process of a child coming into care.
Well, what difference does that letter and brochure make? They're incarcerated. They're stuck in prison.
Well, we still have to provide reasonable efforts, and part of reasonable efforts is engaging that parent, and we need to make sure that we're giving them all the information they can so that they can be engaged in the process.
I think these notifications are very, very important from a legal standpoint too. Remember, everything you're doing and every decision you make on the front end will affect the back end of the case and your ability to achieve permanency, especially if you have to implement a concurrent plan. The important thing of the notification letter is it notifies the parent of their duty to maintain that parent-child relationship, to pay or provide some sort of support, and then in full disclosure, it also tells them what the ramifications might be if they don't do so.
So engaging the parent in the process. It's important for parents to maintain a relationship with their children, and it is important for staff to help the parents maintain this relationship. Engaging the parent is a vital part of this process. The worker should invite the parent to participate in FST meetings by phone. Check with the parent's caseworker to schedule the meeting and also to find out if the parent is even allowed to have phone calls. The worker should develop the children's child assessment and service plan and written service agreement with the parent, just as you would any other parent who's incarcerated.
Are collect calls okay, Christy? Can the parent in prison make collect calls to the worker?
Definitely, and sometimes parents have calling cards that they use to call family members, workers, anybody else that they might be involved with, but we're also allowed to accept collect calls. So if a parent calls you from the prison, feel free to answer the call.
Initially, is it hard to make a relationship or get in contact with the worker in the prison?
It can definitely be difficult to get into a prison, especially initially. There's a lot of checks that they go through because they want to make sure that there's nothing that's being brought into the prison that's not allowed. So the first couple times that you visit with the parent in prison, it might be difficult, but what's really key is making sure that you are maintaining contact with the prisoner's caseworker. That will really help out the process.
Some of these people might be in prison for quite a significant period of time. How do you go about developing a written service agreement for any parent that's in prison?
Well, one thing that's important is to find out from the parent's caseworker what's actually available to the parent in the prison. There might already be things that they're working on or things that they've already completed, so that communication is really important. You could put things on there such as a goal of maintaining the parent-child relationship. You want the parent to call you on a regular basis, maybe once or twice a month, to let you know how they're doing. But communication is definitely the key.
What if the parent is going to be getting out of prison in 14 months? And maybe you have a family support team that wants to hurry up and do the TPR before the parent gets out. Do you think that's a good idea?
Well, the incarcerated parent is still a parent. They're still entitled to due process. We're still required to provide reasonable efforts to them. Incarceration in and of itself is not a TPR ground in Missouri. So we need to continue to work with that parent, engage that parent until we find permanency for the child.
Christy, is it like starting over when that parent gets out at the 8 or 10 or 12 month mark?
No, when we're working with the incarcerated parent, we should be working with them from the beginning. We should be providing those reasonable efforts while they're in prison. We should be providing visitation to the child so that when they get out of prison, it's a smooth transition and hopefully we can move the child back home with them quickly. In addition to what we've talked about with engaging the parent is also communicating with the parent's caseworker at the prison to find out what services are available to the parent. We've talked about this a lot, but it's really important to maintain that contact with the parent's caseworker. They can provide you with a lot of information about what the parent's working on and what things are part of their plan while they're in prison. Upon completion of the written service agreement, the worker should send a copy of the agreement to the parent to sign. The worker should also send the parent status reports to keep the parent updated on their child. These forms should be sent to the parent on a quarterly basis or however often. In addition to that, changes are made. If you have a child that moves from one home to another, we should make sure we notify the incarcerated parent just as you would any other parent that's not incarcerated.
Let's talk about communication from the other perspective. What about the parent that writes the worker and says, can you tell me what's going on with my child? Can you send me a picture of my child?
The incarcerated parent has a right to know what's going on with their child at any given point. That's why these status reports are so important. You know, it's sometimes difficult. Some parents might not have phone calls and things like that, but they are allowed to get mail. And so these status reports can keep them updated when we can't talk to them on a regular basis. We are allowed to send photos if the prisoner is allowed that. We need to just check with the caseworker and find that out.
Now let's take a look at the type of services that may be available in some of the prisons.
There are many different types of services involved in prisons. They can receive therapy, substance abuse treatment, sex offender treatment, parenting classes. What's important is just to ask the caseworker what kind of services they have available at the prison. Some prisons even offer educational opportunities for the parent, including GED classes or life skills classes. Now let's talk about visitation and other contact. Parent-child visitation is extremely important even when a parent is incarcerated. The visitation can help minimize the harmful effects of separation. In order to set up visitation at the prison, staff must contact the institutional activities coordinator of the facility prior to arranging contact. Now, it's important to remember this is the one person that's separate from the caseworker. All other communication that you're doing is usually through the caseworker, but when you set up visitation, it's important to contact the institutional activities coordinator. And a listing of those can be found on the intranet under other helpful resources. Visits can be done in person or via teleconferencing. Children and parents can also maintain contact through letters, phone calls, email, and audio tapes.
Well, I think from a legal perspective, would like to see that visitation and other contact that's appropriate is considered on a child-specific basis. One of the problems we have is these rule of thumb practices, and they're not child-specific, and it makes me wonder as to how much evidence there really is when you're just using the policy on whether or not there's visitation. Child-specific decision would be based on all the different facts that apply to that particular child or the prison they're involved in. I think the FST makes the recommendations to the court, and if there's going to be any prohibitions or limitations on visitation and contact, those need to be handled by court order. Christy, what about the other parent when we're talking in terms of visitation? The other parent may not want the child to go into the prison or to have contact with the incarcerated parent. What comments do you have on that?
Well, a request by the other parent really isn't enough. We can take it under advisement, but we really should seek out the court's opinion on it and get a court order if we're going to be looking at prohibiting visitation in the prison.
Now let's take a look at the specific criteria for making these decisions on whether or not a child should visit an incarcerated parent or have other contact.
Well, one thing we need to find out is whether the parent is entitled to visitation. They might not even be allowed to have visitation based on whatever their crime might have been. We need to find out whether the parent wants the child to come into the into the prison for visitation. We know that sometimes parents may not want their child to see them in the atmosphere that they're in. We need to look at the parent's criminal conviction, if it's related to why the child came into care, if it's a violent crime against a child. We need to look and see if there's a child-friendly visitation area at the prison, the travel time to the prison, whether we have a relative provider or somebody who's willing to even transport the children. And age of the child can also be important because we know that children that are school-aged might have a difficult time being able to visit at the prison.
If a child can't visit at the prison for some reason it's not appropriate, is other contact possible, and how do you go about making that decision?
Definitely. We can look at phone calls too if that's something that's more feasible. We need to just communicate that with the FST, and when a decision's made we need to communicate with the caseworker and determine if that can be arranged. Sometimes
one of the pieces that doesn't match up really well with the legal system and the social work system is when we're talking about a small baby who has a parent that's incarcerated. Sometimes the parents do the books on tape, or they write a letter to the child, very small child. And Christy, does that count as a quality interaction between the parent and the child?
It definitely does. Part of it goes to the intent that the parent is willing to communicate with the child, that they want to have that relationship with the child. And just because the child is a young age doesn't mean they can't appreciate that communication with their parent.
And actually what Christy has just said matches up with the legal piece. Most of the appellate court decisions say that if you're looking at whether or not you can terminate a parent's right based on their contact with the child, they look at the intent of the parent to have contact and to maintain that parent-child relationship. So sometimes as much as a stamp on a letter and sending a letter, or any type of contact that the parent is attempting, and sometimes they draw pictures, send cards, like I said, letters, any of that would count as an attempt by that parent to maintain that parent-child relationship. The one thing to be careful about when we're talking about visitation and contact is that a court order of no visitation and no contact may defeat your ability to implement a concurrent plan of TPR and adoption. The example would be if you're proceeding for an involuntary TPR on abandoned child. The parent has to be found not to have visited or had other contact with the child for the last 6 months. Well, you may have that period of time where they haven't visited or had other contact, but the fourth element of an abandoned child requires the parent to be able to visit. If there's an order of no contact and no visitation, then that parent is not able to visit the child, and you would not be able to make an abandoned child case in that particular situation.
So let's talk about documenting and obtaining records. It's just as important to document contacts with the incarcerated parent as it is with any other parent. Documentation is important for showing reasonable efforts. And there's various records that we can request from the parent's caseworker. We can get medical information on the parent, mental health information, services that they've completed, any disciplinary issues that they've had, banking records, and contact logs.
Can you explain how all of those different type of records are relevant and important to the documentation piece? Why do we need to know that information?
Well, when you look at medical and mental health information, that can be very important for our child if we are looking to determine if there are any kind of genetic diseases or any other kind of problems that the child might encounter. Services, pretty self-explanatory. We want to know what kind of services they're doing, what kind of services are available for them so that they can be working on their treatment plan. Contact logs can provide a lot of information for us about who's visiting with the parent. You know, maybe there's a relative that's been visiting them with a long time, and we can look at that for placement for the child. Banking records, we can find out if they're employed within the prison, how much money they're making, and whether or not they're able to provide any kind of support to the child.
So all of these go to good reunification efforts and trying to help them maintain that parent-child relationship,
Definitely,
correct?
definitely.
Now we move on to concurrent planning for the incarcerated parent. This is why it's so terribly important to make legally sound decisions when it comes to dealing with the incarcerated parent. You have to remember that there are legal elements of guardianship and legal elements of termination of parental rights that have to be met. The parents are entitled to due process, and the state always has to make its case. So we're going to talk about adoption as a concurrent plan, we're going to talk about guardianship as a concurrent plan, and then we'll talk about the differences. If a parent has worked hard on their services and done everything he or she is supposed to maintain that parent-child relationship, the child may have that relationship for a lifetime, but will not be able to go home with the parent who's in prison. Remember those 60,000 children that have parents in prison in Missouri? 55,000 plus are not in Children's Division custody. So again, that lifetime relationship may not be what you and I envision for permanency for a child, but obviously it works for other families in Missouri. If our child is placed with a relative, then remember that guardianship is always doable as a concurrent plan. If the child is with foster parents, and a concurrent plan would be adoption with termination of parental rights, not so much. You have to really take a hard look at whether or not there's enough evidence for one of the termination of parental right grant. Again, unless a parent consents to termination of parental rights. Let's look at what guardianship involves as a concurrent plan. The parent is entitled to due process, so it's just like the juvenile court case. They receive the documents, they're entitled to a hearing. The state must make its case that the parent is, quote, unfit, unwilling, or unable to parent the child. And again, because the parent is in prison, they clearly are unable to parent the child. This is a great concurrent plan for relatives because of the subsidy piece. You don't generally see foster parents that have the wherewithal to be able to care for these children without subsidy. Adoption is a concurrent plan. Again, let's make some assumptions before we start on this slide. Both parents will consent if it's a voluntary, or there may be an involuntary. But generally you don't do a TPR just on one parent. You're generally looking at both parents. So as we talk about adoption and TPR for the parent that's incarcerated, we're assuming that the other parent also would meet either consented or would meet one of the TPR grounds. So adoption is a legally binding permanency plan because it permanently trumps both parents' rights. And parents' rights may be terminated either in a juvenile court proceeding under Chapter 211 or as part of an involuntary under a Chapter 453 proceeding. Many parents in prison will consent. We've talked about this a little bit, but I think that social worker relationship with the parent in prison and all those attempts to provide reasonable efforts will create the relationship in the environment if a parent does want to consent. Do not forget that on consent TPRs, when the parent is incarcerated, that if they have an attorney, you must go through their attorney in order to obtain a consent. When we talk about due process in terms of the consent TPR, when the parent signs the consent form, they are basically waiving all the due process requirements that they would be entitled to. They agree to submit to the jurisdiction of the court, they waive summons and a copy of the petition, they waive notice of the time of the hearing, and they waive their right to counsel. In terms of an involuntary TPR, we know that Missouri law requires at least one of the 8 TPR grounds by clear, cogent, and convincing evidence, as well as a best interest determination by preponderance of the evidence. There's a specific Missouri statute that says incarceration in and of itself is not a TPR ground. So let me repeat that. Incarceration in and of itself is not a TPR ground. Let's take a look at the bullet point number 3. The lack of reasonable efforts is also a barrier to TPR. Because remember, if you're doing an involuntary termination of parental rights, you have to have the evidence to meet one of the TPR grounds. And in most cases, without providing reasonable efforts to the parent, we will not be able to make that ground.
So what about permanency for the child who grows up before the parent is out of prison?
I think this is why it's so important to involve that relative placement. Because if you take a good look at whether or not there's enough evidence for a TPR ground when a parent has done everything they're supposed to do in terms of maintaining the relationship and providing the working on their services like they're supposed to, then you may not have a TPR ground, which means the foster parents would not be able to adopt. But if that child is in a relative placement, that parent has that relationship for a lifetime, and there's always enough evidence to do a guardianship. TPRs are lost at trial and at the appellate court level for just this reason. People see incarceration in and of itself, oh, that's not in the best interest. We can't have permanency for a child, even though the parent's doing everything they're supposed to. We can't have permanency for the child because they can't go home to that parent. So again, the courts are going to say incarceration in and of itself is not a TPR ground, and that's when the importance of relative placements and guardianships will get you where you need to be.
So what if both parents are incarcerated and there are no suitable relatives or kin?
Christy, I think this is a very hard one for social workers because the legal part of this just does not match up with the social work piece. Yes, we want these kids to achieve permanency, but we cannot just TPR and move on to adoption because it's in the child's best interest and the fact that the parent's going to be in prison for the child's entire life. These kids will have to remain placed in their foster care placement. Reasonable efforts will have to continue to be provided to the parent, try to maintain that parent-child relationship until the permanency plan is changed otherwise.
So we talked today about a little bit of information about incarcerated parents and what kind of resources are available, but there's also an option to look at the Family and Friends Handbook that was created by DOC, which contains a lot of valuable information that we haven't discussed today, and we provided the address for you there. We also have parenting programs for prisons and probation and parole information on the CD intranet under other helpful resources. We hope that you have learned that incarcerated parents aren't out of sight and out of mind. We owe it to the parent and the child to work together, and we hope that today's training has given you information and tips on how to do that.